12:10 says my phone. Good enough for me. Hello, everybody. Welcome online as well. Thank you so much for joining us today for a wonderful panel to discuss what I think it's fair to say, and I certainly suspect the panelists won't disagree with me, a topic in the criminal justice system that could not be more ubiquitous, while at the same time being under-discussed, under-analyzed, under-explored: plea bargaining. It really is what defines our criminal justice system. In fact, the Supreme Court, I guess close to a decade ago, described our criminal justice system as a system of pleas. And yet you wouldn't know that, certainly from TV coverage or even from the sort of general discourse about how our criminal justice function. Trials get all the attention, whereas pleas really produce all the convictions. And so against that backdrop, incredibly grateful to have had from the University of North Carolina, Professor Carissa Hessick, join us to talk about her book, and have spectacularly Ohio Supreme Court Justice Donnelly to comment on that and other topics, and then our own Professor Simmons and Zuckerman to kind of lead us along the way. I'm especially excited. I'm Doug Berman, the director of the Drug Enforcement and Policy Center. Thanks to Yana Herdnova, Holly Griffin, and the entire DEPC staff for helping us to make this a reality. I'm not only especially excited that leads me to talk fast, but I'm excited that I get to go in the audience, because Professor Zuckerman was grateful I'm grateful that he was willing to be our official moderator, though he's got some perspectives to share on these matters as well. And so I'm going to now officially kick it to him to take over. But please, if you're interested in this topic or any other related to the intersection of criminal justice and drug policy, especially, reach out to me, reach out to other folks involved with DEPC. That's for you folks online as well. And thank you so much for being here. With that, and no further ado, take it away.
Thank you, Professor Berman. Thank you to all of you here in Drinko 244, and to all of you in the ether with us as well. I am just thrilled to introduce all three of our panelists today. I will start with our guest from out of state, Professor Carissa Byrne Hessick. She is the Anne Shea Ransdell and William Garland Buck Ransdell Jr. Distinguished Professor of Law at the University of North Carolina School of Law, where she teaches criminal law or focuses on criminal law. She does a lot of things that are adjacent to that issue too. She's the author of multiple law review articles, essays, op-eds on things like plea bargaining, the powers of prosecutors, how prosecutors are selected, Sixth Amendment sentencing rights. And she is the author of the 2021 book, Punishment Without Trial: Why Plea Bargaining is a Bad Deal, which she's here to tell us about today. One person who figures in that book is Ohio Supreme Court Justice Michael Donnelly. He is the 160th Justice of the Supreme Court of Ohio. Prior to joining the Supreme Court of Ohio, and I'm not going to give his full bio because his reputation precedes him, but prior to joining the Supreme Court of Ohio, Justice Donnelly served as a trial judge on the Cuyahoga County Court of Common Pleas, that's Cleveland, for 14 years, and was also an assistant Cuyahoga County prosecutor from 1992 to 1997. Last but not least, we are joined by our own Professor Rick Simmons, who you all know as a national expert on criminal procedure, especially issues where technology intersects with the Fourth Amendment. Like Justice Donnelly, Professor Simmons has also served as a trial level prosecutor for his part from 1996 to 2000, I think, as an assistant district attorney for New York County, where he prosecuted felonies from investigation and arraignment all the way through plea bargaining and, yes, trial sometimes. Of course, today we're not here to talk about the now roughly 3% of cases that end in a trial. We're here to talk about the roughly 97% of cases that end in pleas, which is the focus of Professor Hessick's new book. So I'm going to give her the floor to let her speak a little bit about that book, and then I'm going to turn things over to Justice Donnelly and then Professor Simmons to respond. Then we'll have a little bit of open conversation, and then we'll open it up to all of you with questions. So with that, Professor Hessick, take it away.
Thank you so much, Professor Zimmerman. And I should say, rather than just speaking to you off the cuff, even though I love to do that, I thought I would actually read a little bit from the book, since I had more time to work on the language in that and make it sound exactly how I wanted to. Since he's here in person, I'm not going to read from the chapter that features then judge and now Justice Donnelly. But I hope that we'll spend at least part of the time today on the panel talking about the issues that I spoke with him about for the book, which are the costs to the non-defendants in the system, the costs of truth, the cost of justice, that we often don't think about nowadays when we talk about plea bargaining. Okay, so let me get started. When Damian Mills got a call from his cousin telling him that the police were looking for him, he was anxious. Damian knew that the police suspected him of committing some other crimes, but his cousin told him that the police wanted to talk to him about a murder. Damian wasn't always on the right side of the law, but he didn't know anything about a murder. When the police caught up to Damian, they accused him of being involved in the murder of a man named Walter Bowman. Walter was at his son's Sean's house on the evening of September 18, 2000, when three men wearing bandanas and gloves burst in. The men shouted for everyone to get down. Walter, who was in the bedroom, was shot when one of the men fired a shotgun through the bedroom door. The masked men fled right after the shooting. Sitting in an interrogation room weeks after the murder, Damian could see photos and other evidence from the crime scene that the police had hung on the walls. But he knew that he hadn't killed Walter Bowman. He had not been at Sean Bowman's house, and he had not been involved in the shooting. Some of the other people who supposedly committed the murder with Damian confessed. The police told Damian to confess too. The police told Damian various details about the murder, and they instructed Damian to tell them that the other people in the group had done certain things the night of the shooting. Damian told the police that he couldn't tell them any of those things because they weren't true. The police arrested him anyway and sent him to jail. They kept Damian in an isolation unit, which separated him from everyone else at the jail, and he was allowed out of his cell for only 1 hour each day. After spending 2 days in isolation, Damian was again interrogated by the police. They questioned him without a lawyer present, and they pressured him to say that he and his friends had been involved in Walter Bowman's murder. Damian knew that he'd had nothing to do with the murder, but he was worried that the police were going to say that he had pulled the trigger and killed Bowman. He was also overwhelmed from his time in isolation, so he confessed. Damian couldn't afford a lawyer, and so the court appointed one for him. The lawyer told Damian that he had lost 3 cases just like his at trial, and so he recommended that Damian plead guilty. Damian took his lawyer's advice. He went to court. He told the judge that he wanted to enter an Alford plea, which, as you guys probably know, is a special type of guilty plea that allows a defendant to be convicted without admitting that he'd actually committed the crime. But the judge wouldn't let him. So Damian said he helped kill Walter Bowman and pleaded guilty to a murder he didn't commit. He served more than 10 years in prison. Damian's story is not unique. There are countless others who have pleaded guilty to crimes they have not committed. In Massachusetts, thousands of drug convictions were thrown into doubt when Annie Dukin, a chemist with the Massachusetts State Drug Lab, admitted that she had contaminated samples and faked test results. Innocent people pleaded guilty when they were faced with false test results, saying that they had possessed drugs. Only after years of court battles did people get their convictions reversed, but many served time in jail and prison before that happens. Massachusetts is not the only place for the crime lab scandal. San Francisco, Houston, Oklahoma City, and St. Paul all had serious scandals too. Those scandals also revealed that false test results had led innocent people to plead guilty. False drug tests aren't just the result of a few bad apples in state labs. In-depth reporting from ProPublica has shown that drug field tests are incredibly unreliable. Police departments across the country use these tests so that officers can quickly determine whether to arrest someone for possessing drugs. For example, one test turns blue if the material being tested is cocaine. But it also turns blue for more than 80 other substances, including some acne medications and common household cleaning materials. In addition to the unreliable nature of these kits, police departments often fail to train their officers to use them correctly, and so officers end up incorrectly interpreting the results and arresting people. Desperate to get out of jail and terrified of the mandatory minimum penalties for many drug crimes, many of those innocent people plead guilty. Damien's story, as well as the stories of innocent people in Massachusetts and elsewhere, raise an extremely important question. Why does our system pressure innocent people to plead guilty? The answer is simple. Innocent people are pressured into pleading guilty because everyone is pressured into pleading guilty. Ours is a system of pressure and pleas, not truth in trials. Trials are supposed to tell us whether a person that police suspect of committing a crime actually did something wrong. Only if a jury believes law enforcement and convicts the defendant is a person supposed to be punished. But we've gotten rid of trials and replaced them with a system that hands out punishment based only on what police and prosecutors suspect. Maybe that seems like a good idea for the people who actually did commit a crime, but it's obviously a disaster for the people who did nothing wrong. Innocent people plead guilty because anyone who goes to trial and is convicted will get a much longer punishment than someone who pleads guilty. When there is evidence that suggests an innocent person is guilty, like the false confessions about Damien or the incorrect drug tests in Massachusetts, the risk of being convicted after trial can't be ignored. Now, the difference in punishment for those who plead guilty is by design. Those longer punishments after trial exist so that people will feel pressure to plead guilty. And the possibility of more punishment isn't the only pressure people feel. Our system of pretrial detention places a lot of pressure on people to plead guilty too. For those people who are accused of low-level crimes, agreeing to plead guilty can mean walking out of jail that same day rather than sitting in jail for weeks, if not months, waiting for their trial to take place. Even if a jury eventually acquits them, they don't get that time in jail back. We've managed to punish them before we convict them, so they might as well make that punishment as short as possible. Keeping people in jail before trial isn't the only way that we punish people before we convict them. We also let police officers take their money and property based on just the suspicion that the money is a profit from crime or that the property was used to commit a crime. We also let court systems charge people fees for staying in jail, posting bail, or even impaneling a jury. When those fees are due before conviction, then they punish both the guilty and the innocent. And when they apply only after conviction, then they are another way to pressure people into pleading guilty. Even the court process itself can feel like punishment. People have to sit in dingy courtrooms for hours, waiting for their cases to be called. They have to miss work and lose wages to appear in front of a judge. Most often, those appearances are just going to result in yet another court date being set, which will require another trip to the courthouse and another day off from work. That process wears people down, making them willing to accept a plea bargain just to avoid more and more trips to the courthouse where nothing happens. Our system of pressure and pleas doesn't just lead to the punishment of innocent people. It also damages the very foundation of our criminal justice system. Instead of providing a process that's supposed to sort out the truth of what happens, our system just lets lawyers negotiate an outcome. Lawyers negotiate about what the defendant's sentences will be, and they sometimes negotiate about what crimes the defendants will admit to committing. The specific crimes the lawyers pick may have nothing to do with what the police think the defendants actually did. It's just what the lawyers were able to agree on, usually because it has a punishment that both sides find acceptable. By abandoning trials and embracing negotiation as the process for our criminal justice system, we've given up on the search for truth itself. As a result, we can't rely on a defendant's conviction to tell us what actually happened. The defendant may have committed a much more serious crime, or he may have committed no crime at all. It's hard to overstate the extent to which the modern system has circumvented most every constitutional and political protection against punishment. Whether a person faces time in jail or loses property is, in many instances, dictated by hastily made decisions by police or prosecutors. Plea bargaining ensures that those hasty decisions remain hidden from view and are never subject to judicial review or public scrutiny. What is worse, the current system creates a feedback loop that all but guarantees that the problems with the current system will only get worse. In recent years, the conversation in this country has moved towards the idea of criminal justice reform, but very slowly. Congress and some state legislatures have modestly decreased sentences. A few states have decriminalized marijuana possession, and some cities have elected prosecutors that ran on progressive platforms of change. But these modest reforms and reformers are unlikely to make much of a difference unless and until we address the dysfunction at the core of our criminal justice system. Our system is now designed to impose punishment without trial, and that is a fundamental change to the very foundations of the criminal justice system. Minor sentencing reforms and a handful of new prosecutors can't undo those structural changes. They're like Band-Aids on the gaping wound that is mass incarceration. More importantly, those small changes can be undone at any time. Even when they talk about criminal justice reform, lawmakers continue to increase sentences, and a progressive prosecutor could be voted out of office if the political winds change. Only when we realize that the entire premise of the criminal justice system has been undermined can we start to focus on reforms that could have a real and lasting impact. We need more than slightly less harsh laws and prosecutors who take a less punitive approach to their jobs. We need to make it more difficult for the government to punish people without trials.
Thank you very much, Professor Hessick. Justice Donnelly.
Good evening or good afternoon. It's great to be here. It's an honor. And I would just say that what Professor Hessick just wrote is absolutely, in my experience of 14 years on the trial court bench, 100% accurate. And I think by writing the book she did, she performed a great public service. I think this book should be required reading for every law student, especially those students that are going to go into the criminal justice system, and also policymakers. And if you read her book, one word that consistently comes up over and over again is the word leverage. And that is exactly what I saw for 14 years. I saw prosecutors who were instilled by our legislature with tremendous leverage to exert plea bargains from people who may or may not have actually committed what they were originally accused of. I came from the largest trial court in the state of Ohio, 34 common pleas judges. If you're a podcast fan, it was the focus of Serial Season 3, which exposed a lot of the problems in the criminal justice system. I was only mentioned once in episode 2 by Sarah Canning, and she said that I was the only judge in the whole courthouse that would not meet with the parties in the back room as regarding plea bargains. Early on, when I became a judge, I started engaging with the parties the same way I learned as a young prosecutor. We'd have a tentative agreement on a case, and then there was one other step that had to take place. We had to go back into the chambers, meet with the judge, and see if the judge would be amenable to accepting that plea agreement or not. And after I became a trial court judge in 2005, I started to question that practice because we were discussing issues that may have profound effect on the defendant's life. They involved, in some cases, victims. And I wondered why we don't have these discussions out in open court where those stakeholders in that case could hear what was being discussed that was going to affect their lives. So one day I made a change. I told my bailiff, I'm no longer going to have these discussions in the back room because I call this the greatest epiphany of my career. I came to the realization that no one in the plea negotiation process should ever say anything in the back room, including the judge, that they would not repeat verbatim on the record. So one day I went out and said, let all the attorneys know we can have the same discussions that we've been doing, but we're going to do everything on the record. And it was like the heavens opened up. And I realized that I wish I had been doing this all along. And I came to the conclusion that this is the way it should be done. And I have not had anyone convince me otherwise since then. And as was mentioned earlier, I called myself a trial court judge. I certainly presided over every type of trial you can imagine in the general division, from capital murder, rape, to many drug cases. But if you were to look back on my career, that 14-year career, and do a breakdown of how much time I spent in trial versus how much time I spent discussing with parties plea negotiation and sentencing people, the vast majority of my time was doing just that. Having those discussions and sentencing people. And that is a system, the leverage that you'll read about if you read, and I highly encourage you to do so, Professor Hessick's book. It exists there on the front end of the system, on the back end of the system. There's all these pressures. I'll just describe a situation in Cuyahoga County, which I described as the culture of plea and release. And you would see defendants who were charged with very serious crimes, and their bonds were set accordingly, because that's how we set bond, not based on the underlying facts, but what the charge is. They had very high bonds and they couldn't make those bonds. And as a result, they sat in the Cuyahoga County Jail sometimes for months, while their attorney and the prosecutor exchanged facts about the case through the discovery process. And oftentimes they discovered that the facts really didn't support what the original charges were. So they would come to an agreement where a felony one, which in Ohio is the most serious indeterminate felony, would be reduced in exchange for a plea to an F4 or F5 low-level felonies, or a misdemeanor with a promise of probation. And the defendant would be brought out, and we'd go with the plea colloquy. We'd go through the plea colloquy. I would accept the plea, and then I would set the matter for sentencing. I'd get a pre-sentence report. And you could predict with absolute certainty what would come out of the defense lawyer's mouth after I accepted that plea. It would be, Your Honor, maybe we'd be heard on bond. And I'd say, okay, you just saw the felony one just went down to a misdemeanor, judge. Can my client get out? It's probationable. The prosecutor has no objection. I'd say, is that correct? The prosecutor would say yes, and they would be released that day. But you can imagine what the conversation that took place before that plea. The defense lawyer went in and said, great news. I just had the prosecutor agree to reduce your F1 or F2 to an M1 with the promise of probation. And you can imagine the defendant say, well, what if I'm not guilty? What if I want to go to trial? Okay, well, we can get you a trial date, but that's going to take place about 2 months from now, and you're going to have to remain here. And I can't promise that date will go forward, or I can't promise you'll get the same sentence if you get found guilty. But if you walk out today, you can get the plea, you leave today, and you get agreed probation. So you can see, as what Professor Hessick said, even if you're innocent, what are you going to do?
Thank you, Justice Donnelly. Professor Simmons.
Well, thanks very much, and I'm honored to be here with this distinguished co-panelists here. I am going to disagree with the main premise of the book, that plea bargaining is a bad deal. But first, I want to say it's a terrific book. It highlights and provides masterful, accurate critiques of many parts of criminal justice system. And these problems that it talks about certainly make plea bargaining less fair. They also make trials less fair. They're things we should fix. So we've already heard about a lot of these already from my co-panelists. There's a chapter on overcharging, overcriminalization, the high sentences that we have, excessive collateral consequences for people who are convicted. Those are all problems, certainly. There's a chapter on bail being set too high and people being kept in jail before trial, which I think is an injustice. There's a chapter on court fees and civil forfeiture, which is unfair and disproportionately affects poor and people of color. There's a chapter on the deplorable state of misdemeanor courts and how due process doesn't exist there, and how, as we heard, defendants have to keep coming back for appearance after appearance for continuation until finally trial might happen or might happen months later. a chapter on fictional pleas, which Justice Donnelly can tell you more about than probably anyone else in the country, where you plead to something even though that's not even what the charge was and not what you did. So all of these things I think are issues. And the book has another chapter on how to fix a lot of these issues about not requiring defendants to appear for every appearance, to limiting pretrial detention, and a lot of other reforms. I think that's terrific. But I want to focus on plea bargaining itself and why I think it's actually not a bad deal. The book, I think, makes two critiques of plea bargaining, the process itself. One is that it forces defendants to pay essentially what it calls a trial penalty, a price for exercising the constitutional right of going to trial. To me, the term trial penalty is just wordplay. It's the other side of plea bargaining. You get a discount for not going to trial. You pay a penalty to go to trial. It's the same thing. It's not unethical. It's literally the point of having plea bargaining. You're not being exercised, you're not being punished for exercising your right. You're being rewarded for waiving that right. Defendants waive trial rights all the time. Defendants sometimes waive the right to an attorney, sometimes waive the right to a jury trial. During a case, they might decide to waive the right to present a case. They do that very often. They might waive the right to cross-examine certain witnesses. So waiving trial rights is not something that is new or unusual. Here they're waiving all their trial rights and getting significant benefit in return. The other, I think, more substantive critique is that, as we've heard, the bargaining is coercive. Prosecutors can overcharge, sentences are so long that innocent people are coerced into pleading guilty. And I have three responses to that. One is, as I said before, if prosecutors engage in unethical conduct, such as overcharging, I think they should be punished. I think we don't have a robust enough process for punishing prosecutors that engage in that kind of conduct. I think if they threaten to sentence someone to punishment that's more than what the defendant deserves, that's also against the prosecutorial code of ethics. They should never threaten more than the defendant deserves, and that should also be taken care of. So I think prosecutor misconduct at any stage, plea bargain or trial, should never be tolerated. Another response is that I think some of the examples in the book where defendants are threatened with decades of punishment or get a 1-year sentence at trial, that definitely happens. I think it highlights the worst abuses of plea bargaining. A lot of plea bargaining is not coercive to that extent. I don't frankly think a lot is coercive at all. I think it offers defendants a choice. A lot of plea bargaining happens at misdemeanor level. When I was a prosecutor, we'd offer, you're charged with assault, you get 5 days in jail if you plead, or 20 days in jail if you go to trial and lose. If you charge a community with shoplifting, you get 5 days community service, you plead now, 5 days in jail if you lose a trial. Those are the kind of decisions that a lot of these defendants are making. Certainly the book talks about extremely long potential sentences for drug sentencing. I'm the first to say that drug sentences are way too long, and legislature should revise those and make those much shorter, drastically shorter. But until then, plea bargaining is a way that prosecutors can alleviate these draconian sentences. And the last question, does plea bargaining result in some innocent people pleading guilty? And the answer is yes, it does. I'm sure it does. Trials also result in innocent people being found guilty. We should do all we can to minimize innocent people being found guilty, whether at trial or at plea. And again, the book has some great ideas of how to minimize innocent people being convicted. But there's no evidence that plea bargaining results in more innocent people being found guilty than trials. There's simply no evidence that if we shift from fewer plea bargainings to more trials, we'll get fewer false convictions. I think that happens throughout the system. I think it's a terrible thing. We should work to fix that. But getting rid of plea bargains is not going to help that ratio. I want to say a few minutes of why I actually think plea bargaining is a good deal, why I think it's important for the system. I think it provides a number of good value to the system. One is obviously increases the efficiency of the system. Efficiency seems like a lower tier value, is not as sexy as a lot of other values we want as lawyers, but it's a real concern. We have limited state resources. If you want to increase the number of trials, then you're going to increase the number of prosecutors, defense attorneys, judges, courthouses. You're talking about millions more dollars spent in the criminal justice system. That money has to come from somewhere. It's come from schools, roads, other government agencies. It has to come from somewhere, right? A lot of people might argue, well, we should simply arrest people, arrest fewer people, charge fewer people. That's an argument. I know it's politically feasible in a lot of jurisdictions. I think that's separate from, the size of the footprint of the criminal justice system is separate from whether or not we should have plea bargains or not. So I think there is a resource saving that is significant. But the more substantive reason I think plea bargaining is good is because it allows for flexibility in the system. The criminal justice system is full of strict formal rules, but we don't want a system that's mechanical, that essentially that mechanically pass a judgment every defendant no matter what. There has to be somewhere in the system where individual human judgment comes into play for each individualized case. I think that's what plea bargaining does. Individual prosecutors and defense attorneys can talk about each case and craft a disposition that's good for their specific case. It is dependent eventually, ultimately, on what the prosecutor thinks is best. The prosecutor's job is to do justice in every case. And as prosecutors, we took that very seriously. And this gives power to the prosecutor. To me, that's a feature, not a bug. That's the prosecutor's job, to find a fair and just disposition based on the crime that occurred, defendant's background, resources available, the needs of the jurisdiction, and so on. Most of these factors are not legal, they're equitable. When I was plea bar as defense attorneys, I heard lots of equitable arguments, not legal arguments. This person's raising 3 kids on their own, we should get a break. This person was pressured into the crime by others. This person has a certain background, you should excuse their crime for that reason. Those are the kind of things that prosecutors should and do take into account when they decide what sentence is appropriate. Also, on a jurisdictional level, some jurisdictions want to emphasize some crimes and not others. Maybe they want to take very seriously gun crimes or sex offenses and downplay drug crimes or vagrancy crimes. They can offer lighter sentences and plea bargaining for the crimes they think are not as significant, and then free up resources to take the other crimes much more seriously. And so plea bargaining allows the foot soldiers of the system, the prosecutors, to adjust dispositions based on the needs of the jurisdiction and based on what this individual case desires. My final argument is that plea bargaining does, in some cases, increase the engagement and the participation of defendants themselves. Think of how trials work. Obviously, there are a lot of good things about trials, but defendants don't do a lot in a trial. They usually sit silently. They're not usually called to testify. It's usually a bad idea for them to testify. So they sit back and they watch their attorney essentially make incomprehensive arguments about procedure and law, and then they get a verdict at the end of it. As a plea bargains, and some of them, they get to participate in the process. They get to essentially make choices about what to do. They get to often tell their story to the prosecutor about what happened. That's not something they can do at trial when they usually sit silently and watch other people do the work for them. Obviously, a lot of plea bargaining doesn't do that. Some of it's just routine case processing. A lot of the misdemeanor examples I gave are just sort of the actual price if you decide not to go to trial. There's not a lot of bargaining there. But for a lot of felonies, most felonies, in my opinion, in my experience, there's an interaction going on between the prosecutor, the defendant, and the defense attorney, which gives the defendant more agency and more choice in the system. So I think getting rid of plea bargaining would cause problems. I think serious problems in the system, overcrowding and so on. And I think we should reform the process, keep the good parts of plea bargaining throughout the bad parts of all the rest of the system as well. Supreme Court's already ruled that plea bargaining is a essential part of the system, and constitutional rights apply there, like the right to an attorney. So we could, through rules and legislation, require all plea bargaining with a judge to be on the record, as Justice Donnelly did in his trial court. We could ban fictional pleas, so make sure that the plea bargain fits the facts of the case. We can enforce Brady more seriously at the plea bargain stage, and so on. So I think we should reform the system, make it work better, both plea bargaining and trials as well, to make it more just.
Thank you very much, Professor Simmons. So the first thought I have is just that 65 minutes is not nearly enough time to get into all of this. There's so much we could talk about with these 3 amazing panelists, and I'm already just sad that we can't take, an extra 3 hours on it. But I want to get to some of the more theoretical questions that Professor Simmons raised about the nature of a trial penalty. Is it a trial penalty? Is this really more of a contract? But first, I have a hunch that many of you in the room and also many of you on Zoom may not have ever stood up in open court or been in a judge's chambers, either representing the state or representing a person whose liberty is on the line in a potential plea negotiation, or where that is being, where that's being adjudicated. And I want to just ask our panelists, and I want to start with Justice Donnelly, who has multiple views of this. For the Hamilton fans out there, take us into the room where it happens. What do people want to say behind closed doors they don't want to say in open court? Why might this be attractive, not just to a judge or a prosecutor, but also potentially to a defendant and a defense attorney?
Well, that's a great question. And it goes to one of the themes that I brought up in 2 articles, one for this law school, Truth or Consequences, and one for the Akron Law School, Sentencing by Ambush. And I talk about what takes place in those closed door meetings and why the folks are back there when they've reached a tentative agreement. In the state system, as opposed to the federal system, where the judges tend not to get involved with the plea negotiations between the government and the accused. In Ohio, the judges get very involved to various degrees, and that is something that I've argued is a systemic flaw. because once the parties have reached an agreement, that's not the end of the line. They have to go back into the chambers. They want to describe what the plea agreement is, and they have to ask the judge if he or she is amenable to accepting that plea. And in Ohio, they have wide discretion that appellate court judges are not very interested in interfering with. So in Ohio, you're not even entitled to a plea bargain. So judges back in chambers have various philosophies that all the practitioners have to navigate among the 400 judges in the state of Ohio. Some judges will say, represent back off the record what they're inclined to do in terms of the consequences, the sentencing. They'll tell, if you enter this plea, this is what I'm inclined to do. Or they might, in my opinion, step out of their role as the neutral and say, I don't think that sentence is severe enough. Even if the prosecutor thinks it's okay, I'm sentencing is my realm, and I'm free to go higher than what you're recommending. And so no go on your plea agreement. One other anecdote that was described in Professor Hessick's book, I once had, after I started going around talking about doing things on the record and why I think every judge should be doing this, I have two anecdotes, one from the prosecution, one from the defense, that describe something that would never be said in open court, but that was repeated off the record. And the first one came from a trial court judge who came up and said, I don't agree with you, Judge, about your open doing everything on the record. I said, why? And the judge said, well, I had a prosecutor in my room, and their boss was always riding that prosecutor as not being a zealous enough advocate on behalf of the state. And so we'd have a pretrial conference before a big sentencing hearing. And he would say to me, back in chambers off the record, hey, I'm going to be pounding on the table. I'm going to be asking for 20 years, but I don't think this guy needs to go for anything more than 3. And I thought, well, what purpose did that serve? Was there a victim in the room that didn't know that had been represented and the prosecutor was being disingenuous in court? And then on the other side of the coin, I once was approached by a defense lawyer. And a defense lawyer said to me, I don't like your policy of doing everything on the record. I said, why? And the defense lawyer said to me, well, I practice in front of the same group of judges every day. They assign me cases for work. And it's important that I maintain credibility for them. So sometimes I have a really bad guy with a really bad record. And I'll say back in chambers, I know my guy needs to go for a long time. I know I'll be out there, but when I was told this, my jaw broke down. It fell out. Because I said, you can't say anything in mitigation for your client, but you're representing to the judge that you're fine with sending your client for as long as possible. Lots of things get represented and they don't get repeated. And I brought some copies of what I think is one of my most important dissents since I joined the Supreme Court. And I call it Beware the Backroom Deal. It's State v. Dunlap, and it involves a young man named Kyle Dunlap, who is in prison as we speak right now. And if he's telling the truth, his lawyer told him that if he entered the plea bargain, he had talked to the judge and he would receive probation. But if he received any prison time at all, he would receive 60 days in jail. Based on that advice, according to Kyle Dunlap, he took the plea. The judge proceeded right to sentencing, and the judge sentenced him to 8 years in prison. So he's in prison right now, and he filed a motion to withdraw his plea, no hearing, and that was denied. That's what's wrong with backroom deals.
Do you want to respond?
So you'll have to forgive me. I was a college debater, so like old instincts die hard, but I'm gonna try not to sort of point by point what Professor Simmons said, but it's really, really hard not to. So let me just say a few things. It's true that we can try to recharacterize the trial penalty as a benefit for those who plead guilty. We could try to do that. Should it matter whether we do? The Supreme Court tells us no. They have a line of cases called the unconstitutional conditions doctrine, where they say, look, you can't punish people for exercising their constitutional rights, but you also can't give out benefits based on whether they're willing to waive them. So the state of Ohio can't say to you, we'll pay you $100 if you promise not to vote. Or you can have Social Security benefits, but only if you agree not to go to the church of your choice. The US Supreme Court has said, look, conditioning benefits on the waiver of rights is pernicious, just like punishing people for exercising their rights is. So whether you want to recharacterize the trial penalty as a trial discount shouldn't matter, at least not to lawyers or to aspiring lawyers. I wish that ethics rules would stop prosecutors from acting coercively when it comes to plea bargaining. But when I teach professional responsibility to my students, they always say, it's just this one rule about prosecutors. It is, it's one rule. And it does prevent prosecutors from bringing charges for which they have no probable cause. But if they've gone to the state legislature and lobbied for mandatory minimums on the theory that, you know, this is a law that allows us to catch people who do worse things, and we're going to sentence them under this law, they're able to have probable cause for those watered down charges. And it's been documented pretty well that this is sort of a trend, that prosecutors will go to legislatures, get them to impose harsh penalties, remove elements that are difficult to prove in order to make sure that they can pressure people into pleading guilty, and lawmakers will sign off on that. There's no ethical violation, at least not in terms of something that a prosecutor could be punished for, in terms of giving a defendant more than they deserve, because we as a society don't necessarily agree on what people do and don't deserve, which is actually why I think it's more important that those decisions are made in open court by people who are accountable for them than done in backroom deals. I agree with Professor Simmons that sometimes plea bargaining does good in individual cases. I mean, when I interviewed defense attorneys for this book, they said, plea bargaining causes all sorts of problems, but it's the only tool that I have to get leniency for my clients. That's right. The system that we've built only allows for leniency through plea bargaining, which is why plea bargaining is so attractive. But that's really an indictment of the system that we've set up more than it is an argument in favor of plea bargaining. As for whether we should think it's good that our system's efficient, I suppose I'd say, what has our system done with the efficiency that we've gained? I'm not personally persuaded that we've done very good things with it. If you look at, for example, trends over time, if you look at crime rate changes over time, and then rates of arrests and charging decisions, you'll see that somewhere around when plea bargaining really took off, those two lines diverge from each other. So we see more arrests even when crime is down, because the system is efficient enough to take on more and more cases. And what cases does it take on? Well, in America, we have about 1 million felony cases a year that go through the court system. And, you know, a felony is a crude category, but those are probably the cases we should care about. We have 13 million misdemeanor cases that go through the court system in every year. And are some of those cases worth bringing and pursuing? Probably. But if what the efficiency has gotten us is the ability to chase more low-level crimes, I question how important that efficiency is. Finally, the idea that plea bargaining is a way to do individual justice. I'll just note, I think Professor Simmons was probably a really good prosecutor, the sort of prosecutor that I'd want assigned to my case if I got accused of a crime. But I don't think it's the prosecutor's job to do individual justice in a case. It's not a prosecutor's job to decide who gets convicted or not. That's a jury's job. It's not a prosecutor's job to decide what a sentence should be for a defendant. That's the judge's job. Plea bargaining has changed that. It's disempowered certain people in the system, people who are supposed to be neutral, or people who are supposed to be outside the system altogether, and instead empowered those people in the system whose very job it is to try to punish people. At the end of the day, I agree, we aren't, and we probably shouldn't abolish plea bargaining. But when we talk about reform, I think it needs to be more just than at the edges. It needs to be recognizing that if we build our system on plea bargaining, we shouldn't be surprised when it's so efficient that we are the world's leader in incarceration, and that our decisions whether to imprison or not have really stopped being about making people safe. And I think that's a real tragedy.
To dig in a little bit more on the efficiency question, I want to go back to you, Professor Simmons, then, because you importantly raised it. You know, at the time when, plea bargaining has sort of shadowy origins, and there's a nice kind of kismet to this, because I think Cleveland is one of the first places people start to figure out what's even going on. There's like a report that's done about what's happening in Cleveland, and is it the early 20th century?
Yeah.
And so the Supreme Court doesn't really talk about it much until the 1970s. And by that time, there's already a perceived crime wave and a sort of beginning backlash against the criminal procedure revolution of the Warren Court. Chief Justice Berger says in a kind of famous speech to the American Bar Association, you know, we just need this. We can't process these cases if we don't have plea bargaining. I mean, come on. I want to open it up back to you, Professor Simmons. I mean, is this idea that Professor Hessick raises, I mean, it's really nice we could get rid of this. Could we even have a system without plea bargaining? Do we just absolutely need it?
Well, there's an interesting question there. It's sort of a chicken and egg question of which comes first, right? So we made a decision, for better or for worse, as crime increased in the 60s, 70s, and 80s, especially, to start incarcerating people at massive rates, right? A lot of people don't like that. Some people do like that. That's a political question. Plea bargaining allows that to happen. I'm not sure. I guess I see those perhaps as more separate questions than maybe my other panelists do. I think we made a political decision then that now a lot of people want to backtrack on, that the way to deal with high crime rates is to put a lot of people in prison for a long time. And then one way to have that happen with fewer resources to have plea bargains. If we didn't have plea bargains, would we simply triple the amount of money we spend on the criminal justice system because we're so intent on punishing people who've done these terrible things? I think we actually probably would. I think we'd spend more money on. I'm not a fan of mass incarceration either. I think I'd like to reform that as well, but I see there's a separate question from how we actually process these cases. I think the question is, do some of these cases, is plea bargaining a less just result than trials do or not? Again, I'm not convinced that happens, but I'm also not convinced that the efficiency is the reason why we have mass incarceration. I think that's the choice. That's a choice we made that's separate from that. I just wanted to say, just for the record, I actually agree. I think both my colleagues also about having all this be on the record. Where I practiced in New York, I never met with a judge and defense attorney off the record about plea bargaining. I'll just talk to the defense attorney, and we know pretty much what the judge is going to do, and then we do everything open court. I think that's critical for all the reasons we talked about, transparency and so on. And those stories just not only told are terrifying, both especially the defense attorney, but the prosecutor too. It's disingenuous, and that's not so. And I don't think that's an inherent part of plea bargaining itself. I think it surprised me when I first heard the stories myself.
Professor Hessick, could you kind of help us understand, are we really stretched? Could we have more trials?
Yeah, undoubtedly. So there's a judge in West Virginia who got really annoyed because he was actually concerned, not that plea bargaining was too harsh, but that it was too lenient. He was looking around his community, he saw the opioid epidemic, and he saw the federal prosecutors bringing 12 and 15 count indictments against people who were cooking meth. And then the federal prosecutor would bring the defendant into his courtroom and have that defendant plead guilty to one charge in the indictment and drop all of the rest of the counts. And this guy got mad, right? The judge got angry. He, among other things, he said, "Why are you wasting the grand jury's time? If you really just want the person to plead guilty to this one count, why don't you bring that to the grand jury, have them come in and plead to it here?" It seems to be making a mockery of the system because this is all that's coming through his courtroom. And the federal prosecutor said, efficiency. We have to do it this way. We can't bring these cases to trial. This gives us the leverage that we need to have them plead guilty. And the judge in West Virginia, I'll give him a lot of credit. He's significantly older, I think, than a lot of other judges on the bench. I think he took the bench, I can't remember if it was the year I started kindergarten or the year I was born. He's like, that doesn't sound right. And because he was a judge, he was able to go to the administrative office of the courts and get their data. And he started in 1990. I don't know why he picked it. It was a nice round number. And he went up through 2015, again, nice round number. And he showed that back in 1990, there were 4 times as many trials in the federal courts than there were in 2015. And then he got data on the number of federal prosecutors that have been hired since 1990 and the number of federal judges, federal trial court judges that have been added since 1990. And he pointed out that the system had, I don't think it had quite doubled in capacity. And yet it was having only 25% the number of trials. So his point was, you're wrong. The system can handle a lot more trials. Your office has more people. You guys used to try cases. That's just not what we're doing here. And I would say from my perspective, the story doesn't have a happy ending. The prosecutors in those cases wouldn't offer plea bargains, but they let it be known to the defense attorneys that if their client came in and pleaded to 1 count of the 12-count indictment, they'd schedule a subsequent court date and come in and dismiss the other 11. So nothing really changed, but it does put the lie to the argument about efficiency. And if you look at a chart of the number of cases, or the percentage, let's say the percentage of cases that go to trial as compared to plea bargaining, you see a pretty sharp drop off. So the speech that the Chief Justice Berger gave, the plea bargaining rate was, I can't remember if it was 80 or 90% at the time. And right now, the most recent data that we have from the federal system is it's above 98% of cases plead guilty. And the District of Rhode Island has had 0 criminal trials, and I don't know how many years. So the system is, trials are truly vanishing. We're down to almost 0 trials. And I'll say that's going to change the culture of the court system, right? If you think that there is a 1 in 5 or a 1 in 10 chance that your case might go to trial, as a defense attorney, let's say, you're going to treat that case very differently than if you think there's a 1 in 100 chance that your case is going to go to trial. And that was something that I found very distressing as I did the interviews for this book. It was clear to me that especially in large urban courts, but also in a lot of small rural courthouses, that the cases were processed with a presumption that there would be a guilty plea. And so the factual investigations and the legal research that would have taken place didn't occur because the priority was on negotiation. The priority was on the sort of equitable arguments that Professor Simmons mentioned, right? Oh, my guy had a tough childhood, or look, this lady's already tried to pay restitution. The sorts of things that aren't about factual guilt or legal innocence or suppression motions or those sorts of things. The system has really changed. And I'll add, the percentage of exonerations for people who pleaded guilty rather than gone to trial has gone up significantly in the past 10 years as well. I can't prove that there's a relationship between those 2 things, but it makes me nervous.
I'm going to open it up in a moment, but very, very quickly, I want to just do a lightning round. This is a question that I've stolen, or it's at least a conversion of a question that Professor Berman likes to ask. If you had a magic wand, I'm going to ask each of you to give me one thing you would do. There's I think, agreement we should at least mend it. There's some disagreement whether we should end it, but if you had a magic wand, one thing you would do to change the plea bargaining system today, and then we're going to open it up to you all. Justice Donald.
Okay, I would, number 1, get rid of mandatory sentences that strip judges of discretion and allow prosecutors to use the leverage that they do to coerce pleas. And once I did that, I would require that judges do everything in open court on the record And I would require that our judges, as long as they determined that the parties had negotiated in good faith at an arm's length transaction, that they be required to accept agreed sentences. And if they ever rejected a sentence, they had to articulate the reasons why on the record. That's where I would start.
That's a really tough question. And I'm going to try to maximize the impact. So I'm going to go after the misdemeanor cases because there are so many of them. And I would say that we should treat criminal defendants no differently than civil defendants. And they shouldn't have to show up to court unless they are there to plead guilty or stand trial or be sentenced. They shouldn't have to keep coming back again and again and again. I think that there would be positive externalities for that beyond plea bargaining, but I think that the process is the punishment is a thing. It's not just a saying from the 1970s. It's real. And there are judges who've experimented with this, including a judge here in Ohio who I talked about.
Yeah, I read chapter 6 of Professor Hessick's book. It tells you about, she wrote a letter to a court asking them to allow defendants to read books in the courtroom, and the court refused to do it. You're not allowed to read in most courts. It's crazy.
I know, isn't that crazy?
Totally crazy.
I would,
Professor
I
Simmons.
definitely want their magic wands as well, because I agree with all that, but I'll probably take Justice Donnelly's first one. I think reducing sentences and minimum sentences, but also the sentencing range, which is way too high for most of these. I think that's something that would be good for the system generally. I think we punish people way longer than is necessary for any kind of utilitarian purpose. And I think that would also reduce the number of coercive pleas that we see. It would make the difference between the offer that you're getting here and what you face at trial much closer together, which I think would lower the amount of coercive power that these plea negotiations have. So.
Thank you all. Let's open it up now.
If plea bargaining were restricted, how would you replace the system of a plea agreement in exchange for testimony? I know that's a common thing for like drug deal cases where you'll exchange a lower sentence if you give testimony for who your supplier is. Would there be a correction for that?
It's an interesting example because, before I said I did everything on the record. There was one exception to that. It was still on the record, but the only cases where I would go back in chambers, but with the court reporter would go with us, involve what you just described. If the prosecutor and the defense attorney were negotiating for a better deal, better consequences in exchange for information, well, that obviously is putting the accused in peril. So I wouldn't do those in open court. We bring them back there. But I did that for a specific reason. Number one, I wanted to make a record that if this was going to take place, I don't agree with that policy of law enforcement, but that's between them and the defense attorney. I'd rather have someone who has committed a crime, resolve that case, and then stay out of the criminal world that they were in. However, if they're negotiating for a better deal, I wanted it quite clear on the record that this was not at the encouragement of the court, and I had nothing to do with it. And this was being done, with full knowledge of the peril that they were putting them in, and then we would seal the record. And that's the only exception that I would do it. I saw less and less of that, thankfully, as my career came to an end on the trial court, but it's still used in the federal system, all the time. They'll indict someone and they'll say, we retain our right to go back to the grand jury and obtain more severe charges unless you provide us the information that we want. And so you have to wonder, you have to raise a question. That's pretty coercive action that's taking place in conference rooms that are not on the record. It's never recorded. So.
Yeah, I'll say that I think that those arrangements are the ones that appeal to people most intuitively about plea bargaining. But my experience when I was clerking, I was actually uncomfortable with those cases, maybe the most uncomfortable with those cases, because you'd have these huge multi-defendant indictments where you have 10, 20 people indicted. And sometimes the more culpable people got better plea deals because they had more information to trade, and the truly little fish didn't have enough information, and so they would get stuck with the mandatory minimum sentences. And that struck me as intuitively distasteful and maybe undermines that system altogether, but I'm not really sure. It certainly leaves an awful lot in the hands of the prosecutors, though.
Yeah.
So full cards on the table. I want to be a defense attorney. I didn't have the chance to read your book yet, but I did order it during the panel. So that's I
My
guess.
publisher will be delighted.
You should have brought a bell to ring every time.
So I guess that the commonality across the board is that this is at this point kind of a necessary evil. So from a practical perspective, there's kind of ranging from 1Ls through 3Ls at this point in this room. What advice do you have for us going forward on how to navigate that? Because I did a plea on Monday. Client was ecstatic. I was relatively pissed off that the prosecutor just wasn't moving. It was an M1 case. We had all this mitigating evidence, brought the charge down to something that sounds nicer. So obviously there was movement. There was no additional punishment. Prosecutor just wanted the M1, no classes, no intervention, just wanted the M1. So for burgeoning professionals, what advice do you have on how to navigate, I guess, the necessary evil?
I mean, I imagine that my co-panelists would have more practical advice to give. I guess what I would say is, doing the research for the book, I was convinced of one thing that I was very, very surprised by, and that's that culture played a bigger role in how these things played out than I expected. And I think that's in part because there's very little law associated with plea bargaining. Sometimes when there is law, it gets circumnavigated because of the leverage that's given to prosecutors, and because the Supreme Court's not interested in policing these things. So if it's professional advice that you're looking for, I'd say figuring out the culture of where it is that you have to practice is probably step number one. And then realizing if there are things that you don't like, what you probably need to do is try to change that culture more than anything else.
Yeah, I would say as a defense attorney, you're kind of stuck with this kind of system of plea bargaining, because you can't really take a stand without infringing on your individual client's well-being, right? You can't say, no, I'm going to go to trial for this client and then risk that client going to jail. So I think that's tough. That's why where prosecutors, I think, can do a lot more in that system. You know, as individuals, certainly to follow those ethical rules. And I do think there are more ethical rules than you were letting on as far as what prosecutors. I mean, the ABA has rules and states have rules and so on. So
We'll talk about those.
that's fine. Yeah. But, I mean, but there are rules that prosecutors are supposed to follow and they should follow, which is why you all, including you, should become a prosecutor. That's but we'll keep talking about
I've
that.
done for 2 years at this
Well,
point.
you're still here. I'm still going to keep talking. But I do think about that this kind of change, if you do want to reform this, has to come either from judges or from prosecutors. And again, the culture of the office, which is set by the head prosecutor, as well as sort of history, to make sure that these deals are going to be fair, not coercive, and that you're following, once again, so many stories in this book. I read this like, what is this prosecutor doing? This is not the right thing to do. This is not why you should do this. And so I think that's a problem with the prosecutor side, not, again, with plea bargaining itself. So that's, but I think as defense attorney, I think you're, again, trying to change the culture as a defense attorney is going to be challenging.
And it is an irony too, as we talk about, I mean, our society has rules, people aren't always able to follow them. The prosecutors have rules, they're not always able to follow them. This is a problem that kind of transcends humanity, I think, not just, specific professional roles. But I also just want to say, because I think I might be what passes for a criminal defense attorney on the panel, although I don't practice as a criminal defense attorney, I have represented criminal defendants. And I think it evokes a problem that is, I think Professor Simmons was getting at too. There's a very, very provocative article by some sort of legal economists, Oren Bar-Gil and Omri Ben-Shahar, called the prisoner's plea bargain dilemma. And the issue is, if you were able to advise every criminal defendant at once, what would you advise them? You'd say, go to trial. Why would you say go to trial? Because they can't possibly prosecute even close to all of you. But you don't. You have to make that, your client has to make that decision every time, and you're ethically required to advise your client individually and be centered on what's best for them, which is why we're often, as defense attorneys, in a situation where we're counseling someone to do something that at a systemic level may not lead to an optimal result, but for that person in the specific short-term constraints of our society, is sort of the only way the ethical obligation can point. We are almost out of time. I want to just immensely thank all three of our panelists. I want to thank all of you for being here for this conversation. I hope that you will take a chance to read the book, and thanks again.
Reminder of the importance of culture. The culture of lunch can't be overstated, so be sure to pick up your lunch on the way out, and thank Yana Herdova for making sure they were there. And thanks again to all of our panelists. Wonderful job. And like you said, the discussion that could go on and on. Thank you so much. Such a treat to have you here. I'm so excited you get a chance to talk to our students, and you can be done with me, which is good.